How to read or interpret a Florida trust document. Hello, my name is John P.L.L.C. I'm a trust lawyer in West Palm Beach, Florida. Do you ever have a trust dispute or a trust lawsuit in Florida? And one of the issues is, what does that trust document say? You may think it's clear and it says one thing. Somebody else, like a trustee or a beneficiary or a lawyer, may say it says something else. How does a court in Florida interpret or read a trust document? Consider reading the Hansen case. The Hansen case is a 2009 case from Florida's 2nd District Court of Appeal. The citation is 10 Southern 3rd 213. In this particular case, a 2009 Florida appellate trust case, the court tells us how to read or interpret a trust document. And specifically, we know that the pole star, or the main guiding light to trust interpretation, is what did the person who created the trust intend? What was the intent of the person who created it? And secondly, a very important interpretation concept for reading trusts or contracts or wills in Florida is, if the term or the phrase in the trust is unambiguous, if it's clear on its face, the judge reads it, tells us what it says. You don't get to resort to evidence, what trust litigators call parole evidence or extrinsic evidence, to have somebody try to tell the judge what it means. The judge just reads it and tells you what it says. That's very important from a procedural and an evidentiary standpoint. Why? Well, the lawyers in my firm handle trust disputes throughout the entire state of Florida. And I can tell you many, many times we're in court and a lawyer is going to try to tell a judge what a trust document is supposed to say. Many times that's not evidence, and sometimes if it is evidence, such as if the lawyer is sworn in, it's inadmissible. Knowing how to prohibit testimony from coming in is an important part of being a trial lawyer, what we call exclusionary principles of evidence. My name is John P.L.L.C. Thank you for listening.